by all the press comments to say that it would be helpful to make such a workshop. And I really call it workshop because I want it to be very interactive and that we all understand the legal implications of the most important legal documents. Not all of them, the time wouldn't be enough. I guess we would need years for that. So thank you very much for joining, and Rainer for the very nice introduction and for giving me the opportunity to have this workshop. I would like to start with a very short introduction to remind all of us. I really say remind because I believe that all of us are somehow related to nuclear disarmament in any form. What we are actually talking about, and I would start with something I like to call the list of shame. Just that we see the numbers and what we want to get abolished. Every single atomic bomb here is too much. Just looking at the total numbers and comparing 2020 and 2019, we see that there is a slight decrease, which is fine and okay. However, we can also see that the decrease comes from the UK and, sorry, not the UK, UK is a problem. I guess you read the IPB statement about UK wanting to increase their number of warheads, but Russia and the USA are actually decreasing. Everyone else except France on this list are increasing the numbers, and the numbers themselves are good indicators what is happening there, but not giving a total picture of it. So I would like to have a look now at the destructive power of nuclear weapons. You see here 4 so-called atomic mushrooms, and a very small one, like on the bottom, this one, of 15 kilotons. This is actually what hit Hiroshima and Nagasaki, and we all know how disastrous and horrible that was. On the right-hand side, we see an atomic mushroom of an explosion of 350 kilotons, which is now possessed by every nuclear weapon state. On the left, 1,000 kilotons is owned only by USA and Russia. And the one atomic mushroom which actually takes the whole picture is not developed yet. It is theoretically and technically possible, but it doesn't exist. Hopefully it will not. As I said, we know what 15 kilotons can do. Scientists have researched what 350 kilotons can have, what an impact they could have. In 2006, they actually conducted a study examining the consequences of a regional war between India and Pakistan, taking the average of 100 drop bombs on each other. And this would be the consequence of this regional war between India and Pakistan. You are actually looking at the first almost 2 months after the bombs were dropped. You see how the smoke develops, how it covers the face of the earth. In only 2 months, the whole globe would be covered completely, letting no sunlight hit the ground. And this would last for 10 years. We would have a nuclear winter for 10 years. It would be a disaster for life on Earth, for the whole food and life chain. So everyone who would not die from direct explosion or radiation afterwards would at some point starve to death. And this is, just to lead us back, this is 315 kilotons. We are not talking about the more developed ones, which would most probably destroy the whole planet, not the life on the planet, but the planet itself. So this is the introduction. Now that we are all reminded what we want to get rid of, let's start with the law. And I would like to start with a very general overview of international law, as I feel that it might be helpful to understand the implications for the treaty itself. So there are several sources of international law. I here have listed only those which are interesting to us in terms of nuclear disarmament. So we have custom, we have treaty, and general principles of law here on this list. from general principles of law, they are binding to everyone, and of special importance for us is the principle of good faith. We will come back to it later. Treaty as a source of law is very important. Every treaty negotiated and adopted, ratified, come into force, and how they are applied, all these rules are actually compiled in one convention, the Vienna Convention on the Law of Treaties. So we have rules how to negotiate, how to adopt treaties, and how to interpret them, actually. So it is basically what states negotiate between themselves. Custom is a bit tricky comparison to treaty or treaty law. The International Court of Justice defines it as evidence of a general practice accepted as law. This doesn't really give us a big overview, so let's dig a bit deeper into it. According to the ICJ statute, there are two conditions one norm has to fulfill to be regarded as a norm of customary international law. The first one is more objective, or let's describe it as more objective. It is the behavior of a state for a longer period of time, not of a state, it actually should be the majority of states for a longer period of time, and they should act complying to a certain norm. This norm doesn't have to be necessarily written. That's why it actually is called custom. So far, so good. So we can actually see many states complying with a special norm, though this provision doesn't say how many states, and it doesn't actually say how long, it just says longer. The other one is more tricky. The other condition is more a subjective part. We call it opinio juris. It actually means that the state which behaves in that manner, complying with that norm, is convinced that it is acting according to law, according to existing law. So the state has to act for a certain period of time according to that norm and believe that it is acting according to law. That is basically customary international law. And this is binding to all states, and they don't have to accede to customary international norms as they have to accede to treaties or conventions. So this is the basic difference. I hope that this is at least at some point clearer than it was to some of you. If not, we can discuss it then in the Q&A session. And the second part of the table you see here on this slide are fields or bodies or of international law. So they can be composed of all of the sources. They have norms which are part of customary international law, they have treaties or conventions, and they apply the general principles of law. There are many, many more, but I listed just a few here, and they are also actually applicable to nuclear weapons, all of them listed here. So we will actually start with partially international humanitarian law and some of the norms of them, which are also customary international law, which are applicable to nuclear weapons. This leads me to the ICJ's advisory opinion from 1996. It is actually a result of the so-called World Court project. The IPB, the IALANA, and the IPPNW were involved in this, pursuing states, or actually the General Assembly of the UN, to ask this particular question to the ICJ: is the threat or use of nuclear weapons in any circumstance permitted under international law? So, depending on the side you are at, some scientists in literature call it famous, others call it infamous. This advisory opinion is actually legendary, in my opinion. It is a landmark in international law. The court states that the use and the threat of use of nuclear weapons is not permitted under international humanitarian law, or is generally contrary to the principles and rules of international humanitarian law. So let's have a look at these principles and rules. Nuclear weapons have an indiscriminate effect on combatants and non-combatants, meaning that they cannot distinguish between civilians and combatant soldiers. This is contrary to, this is actually applicable to all weapons used in armed conflicts. So this provision actually, or this prohibition derives from this principle. The second principle is not to cause unnecessary suffering to non-combatants. Nuclear weapons, as they cannot distinguish between them, they also cannot prevent unnecessary suffering to those who are actually affected by a nuclear weapon. And the next one is the principle of neutrality, meaning that nuclear weapons will affect neutral states, states that are not involved in that particular conflict. If we take the example of the regional conflict between India and Pakistan, actually the whole world would be affected, and not the whole world was involved in this conflict, just to give an example. And the last one, and I didn't really put them all together because the first three are really connected to or are principles of international humanitarian law, so the law applicable to armed conflicts. But the court, in the advisory opinion, also stressed that they cause widespread, long-term and severe damage to the natural environment. And this would actually be a source then for international environmental law. The court also had a look at human rights and international human rights law and how they are affected. And if you are interested in that, there is ongoing discussion in the UN Committee of Human Rights, and especially the general comment number 36, where they basically urge states to join the TPNW. But we can maybe talk more about the human rights perspective and especially the human right to life in the Q&A section. Let us just shortly go back to the advisory opinion. Why is it unfamous for some people? The court let one question open. It couldn't answer it in the advisory opinion. If the use of nuclear weapons is permitted in an extreme self-defense situation, that means a situation where the existence of the state is at stake. Unfortunately, this question was not answered by the advisory opinion, but what the court stressed in the advisory opinion was that the self-defense, according to Article 51 of the UN Charter, is only permitted with weapons that comply with the rules and principles of international humanitarian law. And the existing nuclear weapons definitely do not. So the court actually limited the right to self-defense with the rules and principles of international humanitarian law. And as long as nuclear weapons do not comply with them, self-defense with them is not permitted. This is now an interpretation of the advisory opinion or taking it all together. However, if one really special thing to the advisory opinion is that the judges involved in it issued declarations, dissenting opinions, other forms of declarations to the advisory opinion, giving their own expression. If you want to see a true fighter for nuclear disarmament, I can only recommend you to read the dissenting opinion of Judge Vermantry. It's more than 100 pages long. I took another one. It's actually from the back at that time president of the ICG, who says in his declaration, which is much shorter, only 12 pages, I think, that it would be quite foolhardy to set the survival of a state above all other considerations, in particular above the survival of mankind itself. He repeats in his declaration several times that if the Court of Justice was not able to answer this question, it was not meant in any way to leave this door open for states to act as they please and to use nuclear weapons. So he made it quite clear that this was not a blue pass to do what they want and to use weapons in any case. It was actually caused by the fact that the court was lacking facts. The nuclear weapon states were arguing in front of the court that in future they might develop nuclear weapons which could then comply at a certain point with the rules and principles of humanitarian law. And because not having more facts on this, the ICG let this question open. So much to the ICG advisory opinion. I would now like to move to the NPT, which was for a long period of time, the most important treaty related to nuclear weapons. It is, generally speaking, in international law, one of the most successful treaties. It has 191 ratifications, so almost the whole world. Israel, India, Pakistan, and South Sudan did not join this treaty. And we have a very special situation with North Korea, which acceded to the treaty, but in 2003, it declared its withdrawal. However, it didn't withdraw according to the rules set in the NPT. The NPT procedure actually requires a state, when withdrawing from the treaty, to inform all other state parties. So basically 190 states have to have a written declaration of withdrawal and explaining the circumstances, why, and the reasons, of course. However, North Korea did this. The declaration was sent to the UN and to the 5 possessing states. That's why it's tricky, and in literature, it's not really certain if it left the NPT. However, we all know that that North Korea developed nuclear weapons. To go now to the NPT itself, it creates actually a world of double standards for the states having nuclear weapons at that time, and on the other hand, states that didn't have nuclear weapons at that time in 1968 when it was adopted, and 1970 it came into force. So it actually froze that situation, that non-nuclear weapon states and nuclear weapon states. It froze the status quo. It allows, at that time, only the actually Security Council member states had nuclear weapons, so it allows them to possess nuclear weapons, and all other states are not allowed to possess or acquire nuclear weapons. It forbids nuclear weapon states to help non-nuclear weapon states to acquire nuclear weapons. So this is why I'm talking about double standards and freezing the status of 1970. There is actually a third pillar to this table. This is nuclear energy, which should be available to all states, regardless if they are a nuclear weapon state or non-nuclear weapon states, for peaceful purposes. But we are now focusing on nuclear weapons, and I didn't want to make this table already too complicated. And then there is this very, very important Article 6, which is binding to all state parties to the NPT, which requires the state parties to pursue negotiations in good faith. I don't want to read the whole article. I just want really to keep this very simple, but I'm trying to get this to extract the most important things. So to pursue negotiations in good faith, to end arms race and nuclear disarmament on a treaty on general and complete disarmament under strict and effective control. this obligation is taken actually by the court in the advisory opinion we were just talking about. And we see here the last sentence is actually from the advisory opinion. And the court says here that this is a general obligation, so meaning for all states, not only for the NPT parties. So all states of the world have actually the obligation to pursue in good faith and to bring in conclusion. So we have here actually a double-folded obligation, not only to start in good faith, and here we have this good faith, the principle of international law, which is very important and stressed even in the Vienna Convention on the Treaty of Laws. So then the conclusion of negotiations leading to nuclear disarmament in all its aspects, so a complete nuclear disarmament under strict and effective control, binding to all states of the world, not only the NPT countries. However, we have seen that this particular obligation was neglected, ignored by so many states, especially the non-nuclear weapon states, for decades actually. They didn't even want to start negotiations. And if they were there, we could still question if it was in good faith. However, we all witnessed that there is a courageous part of the world which took the initiative and started them and concluded them. There is a new treaty. It's new, of course, and we still have to research it, but I'm arguing, and I'm not the only one, that the states who took the initiative for the negotiations and for the NPT himself, they are fulfilling these two obligations from the ICG's advisory opinion, but also from the NPT, because most of the world's states are state parties to the NPT. I guess this is part of the question, how the TPNW relates to the NPT. However, let's now stick to the TPNW, and I would shortly like to have a look at the obligations, because for now we know that according to the rules and norms of customary international law, the use and the threat of use of nuclear weapons is prohibited. Then we have a 185 states which are not permitted to possess or acquire nuclear weapons. And then we have this set of prohibitions, actually, which is very precise, very comprehensive, much more elaborated than the previous ones. Though we have to say that the Non-Proliferation Treaty, the NPT, its goal was quite different. The goal was at that time during the nuclear war to stop the proliferation of nuclear weapons, and it did succeed at that point. There are experts who claim that without the NPT, within the 10 years, so until the 1980s, we would have had about 40 countries having nuclear weapons. So the first aim, the non-proliferation one, is actually achieved, though we have North Korea as an issue. Let's call it issue. So let's go back to the very much elaborated list of prohibitions. We have development, testing, production, manufacturing, acquisition, possession, stockpiling of nuclear weapons. Transfer, to receive, use, or threaten to use is then again, and we have in point A also acquisition and possession from the NPT, but again, much more elaborated. E and F are actually very important. Assist, encourage, or induce any of the activities from A to D, actually. There are a lot of ways how you can assist, encourage, or induce, and especially assistance. Financial assistance could also be covered or is covered by this treaty, which means that the whole financial department for the state parties of the TPNW cannot make any business more with other banks, for example, investing in nuclear weapons research or production or development. And then we have the point G, allow any stationing, installation, or deployment of any nuclear weapons on its territory or at any place under its jurisdiction or control. This point of Article 1 is actually directed to the nuclear sharing countries because they have been basically a loophole in the previous from the previous instruments, we could have argued that the NPT at some point could have prohibited this, at least when nuclear weapon sharing states are making some exercises with the nuclear weapons lying on their grounds. But still, this provision is very specific, and there is no way to interpret it in a way that it allows nuclear sharing. So basically, the TPNW would end nuclear sharing and has the possibility to end nuclear sharing if the nuclear sharing countries accede to this treaty. This is not the end. These are all the negative obligations, so basically the prohibitions. The TPNW has another set of obligations, positive obligations, victims assistance and environmental remediation. Quite similar to the Ottawa Convention. So it actually requires every state party to provide assistance for individuals under its jurisdiction who are affected by the use or testing of nuclear weapons. It has to be noted that this provision does not say from this point. So it actually is valid for all past tests or uses of nuclear weapons, present and future ones. This also, the same is actually for environmental remediation. International cooperation and assistance is actually strengthening the cooperation between the state parties in implementation and fulfilling these obligations, but also if states are in position to do so, it requires them to help. And then it really says, like precisely in technical material and financial assistance to states affected by nuclear weapons use or testing or their victims. The last part of the provision is that state parties that has used or tested nuclear weapons have a responsibility to provide adequate assistance to affected state parties. We don't have this yet. This is a provision if a nuclear weapons state joins, and actually it's the USA. Though it also says tests, so we have a bit more. But this has to be seen how this will be in practice. As I said, it's a new treaty, so we can only relate to the wording of the provisions of the article so far, or in most cases. And the last point, it's not really regarded as a positive obligation, but I would like to have it there. It's the Article 12. So the provision actually requires every state party to encourage not-state parties to accede the treaty. This is, quite new, and it actually makes every state party an ambassador of the TPNW in its further international relations. So they basically have the obligation, according to this treaty, to wow for it, to get more state parties. So the peace movement here is not alone yet. The more the number of the state parties is increasing, the more support we're getting. You see that I'm quite focusing on the TPNW provisions, but it is the star of the presentation, and it is the most comprehensive prohibition instrument we have. That's why I'm trying to bring at least the most important provisions or to present them in a very hopefully simple way. Article 4 actually goes even beyond it. Even the title says the overall goal towards the total elimination of nuclear weapons. And this provision is quite long and quite complex and complicated. I took this wording, I have to say, not from the treaty itself, but it's from the commentary of the IALANA. I have a list at the end where you can have a look at the sources. I didn't list paragraph 1 in here, just in case you're wondering why, because it is actually addressing states that possess nuclear weapons, and that if they want to accede or actually join the treaty, after its adoption, but before its entry into force. So I didn't include it because we actually lost this moment. Every other nuclear weapon state joining the treaty will be joining according to paragraphs 2 and 3. And what is important here, the TPNW requires these states to immediately remove nuclear weapons from operational status and destroy them as soon as possible. The deadline will be determined later by the first meeting of state parties. And we have here a glance at the verification part, which is actually in Article 2 and 3. But it does include a safeguard agreement with the International Atomic Energy Agency and actually oversighting an instrument, not really, a body that will also look at the elimination of the nuclear weapons. This body will, or is not determined yet. It has to be determined by the third parties. And paragraph 4 is also very specific, and it only addresses states that are part of the nuclear sharing. So not really possessing nuclear weapons by themselves, but having nuclear weapons on their territories. And the difference between these two groups of state is that the TPNW requires the nuclear weapon states to immediately remove nuclear weapons from operational status and destroy them as soon as possible. On the other hand, nuclear sharing states are requested that the nuclear weapons on their territory are promptly removed. So the TPNW gives a better, it takes into considerations the different statuses of these two groups and makes even slightly different provisions how to accede to the TPNW, to nuclear sharing states, comparing to nuclear weapon states. This just one last sentence to this provision. It just says how flexible this treaty is and how the drafters of the treaty were taking into consideration the overall picture of the nuclear weapon states and even nuclear sharing states. And to compare all the three presented instruments and with the question, are nuclear weapons prohibited by international law? I think you can now guess that it's quite complicated and that the answer is not as simple as a short no or yes. I would just say not completely yet, because the last one is evolving. We just celebrated its birth, basically. And to sum up these three instruments with the legally binding nature, we have the threat of use and the use of nuclear weapons, which is prohibited for all states. And this is not a question, and they can't withdraw from this. From the NPT, the possession and acquisition is prohibited for exactly 185 states. And here we should add in brackets the issue of North Korea, but North Korea has already nuclear weapons. And then we have this very long list of prohibitions, very much elaborated, also connected to the experience we made of the first two. That's why the provisions of the TPNW are so precise in the prohibition part. Now, or as of, I had a look only yesterday, I'm sorry, was there someone exceeding the treaty today? 54 states, they basically declared their territories to nuclear weapons-free zones. And this actually already has some implications because of the TPNW, even to nuclear weapon states. While they are transferring their nuclear weapons either by water or air, they are now not allowed to cross any territorial water or the air, what is under the jurisdiction of the state parties of the TPNW. So at least they have to change the route. even for the business. You remember the Article 1 prohibiting any kind of assistance? The TPNW state parties are not allowed to make business with banks from not only nuclear weapon states, but nuclear sharing states, or even states under the nuclear umbrella that are researching nuclear weapons, developing them, helping in any other way. So this already has implications even for non-nuclear weapon, or even for states opposing the TPNW. Let's call them like that. So it's not like these 54 states did something and that has no impact on anyone else. This is now binding to them and they have to comply with all these provisions. And here I have listed all the questions I actually wanted to make clear. I have them once again, but I hoped that I have already answered at least part of that in the presentation by now. So how does the TPNW relate to the NPT? As I said, I truly believe that the TPNW builds on the NPT. They stand in no way in competition to each other. They rather complement each other. If you wish, we can even have a further discussion on that. The TPNW gives great acceptance and pays its respect to the NPT, even in the preamble and in Article 18, I think. How does the TPNW relate to customary international law? The TPNW actually reinforces the prohibition of the threat and the use of threat of the use and the threat of use of nuclear weapons. Having it in the set of prohibitions, so it actually complies with that one. And another one, which may be interesting, is the question, can some provisions of the TPNW become customary international law? Theoretically, they can. However, they have to fulfill the two conditions according to the ICG statute. So the majority of states have to comply for a longer period of time to that norm, and the states have to be convinced that they're acting according to law. The second one, we have now a lot of states opposing it, so we are not fulfilling the first one. However, they are still, at least in some parts, acting according to some provisions of the TPNW. The use, for example, already 70 years, no state has used nuclear weapons. The threat is something different, especially if we talk about the deterrence policy. There are even experts who argued that the deterrence policy can be abolished by this prohibition, forbidding the threat of use of nuclear weapons. However, as long as so many states are opposing the TPNW and expressingly saying that they are not complying with it, and I guess in so many statements you have read that they don't want to see or don't accept the development of the customary international law by the TPNW. And this is because of this subjective part, the opinion juris. They're actually making clear that they are not accepting it, at least by now, but this can change. And as I said, the TPNW is just born. This is the status now. We still have the chance, or there is the chance to change that. Can nuclear sharing states join the TPNW? The TPNW gives this option and actually made some provisions only for them. So yes, of course. Would they have to leave the NATO? No, they wouldn't. The nuclear sharing policy is a governmental decision, is not embodied in the NATO treaty, so it wouldn't even require an amendment of the treaty itself. However, they would need to leave the nuclear planning group of the NATO. And the last one, is the TPNW a merely symbolic treaty? I took this merely symbolic treaty because I read it in so many articles after it came into force. And I have to be honest, it was annoying a bit on one hand, ignoring international law or provisions, every treaty negotiated, adopted, and with its entry into force was coming through the same procedure. The Vienna Convention lays down this procedure, and all treaties are adopted at the same way. So, and they are applicable in the same way. So it is a truly, it's a full treaty by international law as any other treaty under international law. Under international law, we don't have second-class treaties or any symbolic treaties. The only power you can measure there, if we can actually talk about power, is how many states have acceded to a treaty and to how many states it is binding. But it is a state as any other in international law. And as I said, it has already implications, at least on the behavior of some of the opponents of the TPNW towards the states that exceeded the TPNW. And now I just have here a small and short list of what I would recommend if you are interested to have a look at, or what I used for the presentation. And I'll make sure that we send this to you afterwards. And that's it. I know that it might be a bit ironic to close this presentation with Albert Einstein, who was already also involved in the development of a nuclear weapon. But we all know that he regretted this at a huge point and was fighting for nuclear disarmament, or at least saying it at the end. Yeah, thank you very much.
Thank you, Amela. To make it very short, it was great. And I think it was very, very helpful as a basic of information, as a deeper understanding about what we are discussing. And I think also as a good ground for our discussion now. I think now we have